Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning, ladies and gentlemen, and welcome to the Florida Supreme Court. I would like to especially welcome this morning a group of some 25 students that we have from the American Government 12th grade class at Godby High School. We welcome all of you here, and we hope that you have an enjoyable educational experience while you're with us. The first case on the docket this morning is Juan Roberto Melendez versus the state of Florida. Ms. Anderson, you may proceed. Keep your eye on the yellow light. When that goes on, it means you're into your rebuttal time.
Thank you, Your Honor. May it please the Court, I'm Gail Anderson representing Juan Melendez. This case involves an appeal from the denial of Rule 3.850 relief following an evidentiary hearing on Mr. Melendez's second Rule 3.850 motion. In the lower court, Mr. Melendez presented new evidence supporting several claims. The new evidence is raised under several different legal theories, those being newly discovered evidence, Brady, and ineffective assistance of counsel. What I'd like to emphasize first here today is that under all of these theories, the law is that the evidence must be evaluated in the context of the trial record for its cumulative effect. The trial record reflects that at trial, the state presented no physical evidence connecting Mr. Melendez to the offense. The state's case was based entirely on the testimony of John Berrien and David Falcon. The state's
Give us enough of a thumbnail sketch of the facts so that we can consider your issues in some factual context here this morning. Could you do that for us?
The facts at trial, Your Honor?
Yes, the facts at trial, just briefly, but especially as they relate to the issues of newly discovered evidence that you've raised here.
Yes, Your Honor. The state's position at trial, which it presented John Berrien and David Falcon to support, was that John Berrien drove Mr. Melendez and George Berrien, who was John Berrien's cousin, to the victim's shop and left them off there, and that Mr. Melendez and George Berrien went into the shop and robbed and murdered the victim, and then were picked up by John Berrien, who then took them away from the scene. George Berrien was never charged with any offense. The defense at trial was sort of a three-part defense, that Mr. Melendez had an alibi, that the state's witnesses, John Berrien and David Falcon, were not credible, and that another person named Vernon James had been involved in the offense.
Well, the theory of the defense at the original trial was that Vernon James had committed the offense, correct?
Right. That's right, Your Honor.
And Mr. Melendez testified at trial that he did not commit this murder, correct?
That's correct. He did. In support of the defense presented alibi witnesses. The defense presented a jail inmate who testified that Mr. Vernon James had confessed to committing the crime, and the defense presented George Berrien to testify that he and Mr. Melendez did not commit the crime.
Well, let me see if I can crystallize the issues that really you presented for us here. Basically, the issue that Vernon James had committed the offense and that there was a confession of Vernon James to a prison inmate was presented to the original jury.
Yes, one witness was presented to testify that Vernon James had confessed.
And what you're presenting to us here is the fact that now there are some other witnesses that assert that Vernon James also confessed to them.
That's exactly right, Your Honor.
And these are other, as I think the trial judges said, other convicted felons.
Some of them are, some are not. There were four witnesses who testified about Vernon James' inculpatory statements. And these inculpatory statements, as Your Honor has pointed out, are entirely consistent with the defense at trial.
Do they exclude the defendant? Do those inculpatory statements exclude the defendant's participation?
Well, they certainly do negate the state's theory at trial. The state's theory at trial was that George Berrien and Mr. Melendez went in and murdered the victim. And when the defense raised the issue at trial that Vernon James had committed the offense, the state argued that the jury should disregard that evidence, that that's not what happened.
But these
So-
statements do not exclude the defendant from committing the crime.
Well, I'm not sure I understand what Your Honor means by that.
Well, did the people say that the defendant did not do this, did not commit the crime, or did they just say Vernon James was involved in it?
The witnesses say that Vernon James was involved. For example, Deborah Ciotti, who was a close friend of Mr. James at the time, testified that before the murder, Mr. James told her that he planned to rob the victim, and that just before he went to the victim's shop, they were down the street from the shop. Mr. James got in his car, drove towards the victim's shop. Ms. Ciotti could see him. He stopped on the corner and picked up two men, and then went to the shop. Ms. Ciotti testified that Mr. Melendez could not have been one of those two men based on his coloring and his height. Another witness...
What about Berrien's testimony? Did he exclude the defendant from...
John Berrien didn't testify about any statements by Vernon James.
Okay.
The other witnesses who testified about Vernon James' statements were Sandra James, who was Mr. James' sister, who said that after in the months after the murder occurred, she confronted Mr. James and asked him if he committed it, and he said that he did not kill the victim, but he was there when the victim was killed. Another person who testified about inculpatory statements by Mr. James was a woman named, Janice Dawson, who had met Mr. James in December of 1983, which is after the offense. The offense was in September of 1983. She met Mr. James in December of 83, and then during 1984, while she and Mr. James were in separate jails, they corresponded, and Mr. James told her in letters that he was concerned about being taken back to court in Polk County about the victim's murder because he was afraid he would get death or life in prison. And this correspondence was occurring in 1984, and Mr. Melendez's trial was in September of 1984. The fourth witness who testified about inculpatory statements made by Mr. James was Dwight Wells, who was at the time of Mr. Melendez's trial, was a public defender. Mr. Wells had previously represented Mr. James. At the time of Mr. Melendez's trial, Mr. Wells represented John Berrien, and Mr. Wells was not representing Mr. James. However, Mr. James asked to see Mr. Wells at the jail, and Mr. Wells went to see him, and during that conversation, Mr. James told Mr. Wells that he was involved in committing the murder, that he was at the victim's shop, and the victim had made some overly aggressive sexual advances, and that the murder occurred as a result of that.
Did Mr. Wells give any explanation of why he didn't come forward sooner?
He did not.
Was he asked?
He was asked about whether or not he told this to various people, such as Mr. Melendez's attorney, such as the state attorneys. He couldn't recall who he spoke to. He believes that he told somebody, but he doesn't recall having any conversations with Mr. Melendez's trial attorney about it. And Mr. Melendez's trial attorney testified that Mr. Wells had not told him about this conversation.
Can you elaborate on that a little bit? Because I must say I'm very concerned that apparently we have an attorney testifying that he stood by, and I assume that the context of his testimony is that he believes that your client is not guilty He believes this other person is guilty based on direct conversations with this other person. And yet he stood by and watched your client be tried, convicted, sentenced to death, and never spoke up or never said a word. Now, there was an evidentiary hearing here, and of course it's the trial court's role to evaluate credibility and such as that. But wouldn't that be a substantial factor against the credibility of this attorney witness? That is, that he did stand by under those circumstances, being fully aware that your client was tried, convicted, sentenced to death, and that he never said a word. I mean, in addition to the obligation and knowledge that an average citizen would have, now we're talking about an attorney, and an attorney that's very familiar with the criminal law and the obligations of people to come forward. And there's no explanation on this record?
Your Honor, I agree that it's disturbing, certainly disturbing to Mr. Melendez, and all that Mr. Wells could recall was that he had this conversation with Mr. James. He did believe it was important, and that he believes that he told someone, but he doesn't recall who, or even whether it was within his office or whether he told the state attorney's office.
At the time, he was representing Barry and the co-defendant, correct?
That's correct, Judge. Now, based on the testimony of the four witnesses whose testimony I've just summarized, who testified about Mr. James'
Any of this testimony or evidence involved in the Berrien trial?
Mr. Berrien did not go to trial. He pled no contest to being an accessory after the fact. So there was no testimony. The circuit court denied relief as to the claims based on the inculpatory statements of Mr. James. And Mr. Melendez's arguments about why that denial was incorrect are set forth in the briefs, and I don't want to go into all that in detail here today. But there's one point that I do want to emphasize. The circuit court said that 4 out of 5 of Mr. Melendez's witnesses were not credible. The 5 witnesses that the circuit court was referring to are Deborah Ciatti, Janice Dawson, Sandra James, John Berrien, and Dwight Wells. Mr. Melendez's briefs discuss the reasons that the circuit court's credibility determinations aren't reliable and are contrary to the record, and I also don't want to repeat all that here today. The point I want to make is that in saying 4 out of 5 were not credible, the court was saying that one witness was credible. Now, it's difficult to discern from the order which of these witnesses the court is talking about. The court did specifically say that John Berrien was not credible. As to the other 4, the court was not as specific. The state's brief assumes that the witness that the court found to be credible was Dwight Wells, the attorney. However, although apparently finding Mr. Wells to be credible, the circuit court said that his testimony didn't satisfy the Jones test. However, looking at Mr. Wells' testimony in the context of the record as a whole, our position is that Mr. Wells' testimony alone does satisfy the Jones test and does entitle Mr. Melendez to relief. The circuit court, in discussing Mr. Wells' testimony, said that the physical evidence at the scene contradicted that testimony. That is simply incorrect. For example, what Mr. James had told Mr. Wells was that he was at the victim's shop. The victim made overly aggressive sexual advances, and that led to the victim's murder. The physical evidence found at the shop regarding the victim's death indicated that there was some kind of sexual encounter. The medical examiner testified at trial that He performed examinations on the victim to determine if there had been any sexual assault because of the circumstances in which the victim had been found. The police testified that the victim was found dressed only in underwear and socks. The police also testified at trial that the victim was known to arrange sexual encounters for after hours after the shop was closed. All these matters are consistent with what Mr. James told Mr. Wells. Now, in order to analyze how what Mr. James told Mr. Wells fits into the trial, it's important to understand that the state's case at trial was weak. Mr. Melendez's briefs discussed the weakness in the state's case, discussed the fact that this was a very close case, and the state's brief has made no effort to say otherwise, that there was overwhelming evidence or that it was a very strong case. In a circumstance like this, where the state's case is weak, the U.S. Supreme Court has said that a verdict or conclusion only weakly supported by the record is more likely to have been affected by an error than one with overwhelming record support. Here, the verdict is only weakly supported by the record. Mr. Melendez, the state's case was weak. Mr. Melendez's defense attorney presented evidence of innocence. Mr. Melendez's defense attorney testified that he would have presented additional evidence about Mr. James had he had it, particularly the testimony of Mr. Wells, who the defense attorney believed the jury would have found to be a credible witness.
Let me ask you this, Ms. Anderson. Is there any conflict that came out in this record on the 3.0 and 3.850 proceeding concerning the fact that Melendez handed the jewelry to, starts with B.
George Berrien.
Berrien. And to Berrien, any conflict with that part of the testimony?
John Berrien testified at the hearing in this proceeding that at trial he had testified that he saw Mr. Melendez hand jewelry and a watch and a gun to George Berrien at the train station. At this hearing, John Berrien testified that that was not true, that he had not seen Mr. Melendez.
But he pled no contest to accessory after the fact.
Yes, he did.
Which basically is based on the fact that he received that jewelry from Melendez.
No, you're confusing John Berrien and George Berrien. George Berrien is the person who the state alleged went into the shop with Mr. Melendez, and George Berrien is the person whom the state said took a train the next day. And George Berrien is the person to whom Mr. Melendez allegedly handed this jewelry. Not John Berrien. And George Berrien,
was there any evidence presented at this 3.850 proceeding that somebody else handed the jewelry to Berrien?
to George Berrien?
To George Berrien?
No. What John Berrien said is that that never happened. He never saw that. He never saw Mr. Melendez hand jewelry and a gun to George Berrien. I'd like to reserve the remainder of my time for rebuttal. Thank you.
All right. Ms. Sabella?
May it please the court, I'm Candace Sabella representing the state. I think the first thing I need to point out is that this is a second 3850. Before you get to any of these questions, they have to show the hurdle that they could not have found any of these witnesses at their prior 3850. And it's the state's position that that simply has not been established. For example, they allege that they could not have found Janice Faye Dawson, Sandra James, or Dwight Wells until they got the case file from the murder of Vernon James. That is simply not supported by the record. Sandra James was Vernon James's sister. Clearly, Vernon James has always been the target of their defense. When they were investigating the original 3850, Sandra James would have been a natural person to go to. At the evidentiary hearing, their investigator testified that when he spoke to Sandra James, that she is the one that gave them Deborah Ciotti and Janice Faye Dawson. That information clearly was available at the time of the initial 3850. Their failure to present that then bars them from raising it now. It is not newly discovered because it fails the second prong of the Jones test.
Did the trial court make any findings as to these requirements or issues?
Yes, Your Honor, he did.
And did the trial court make a finding like that?
What the trial court found, was specifically with the second prong of Jones, is that Sandra James and Deborah Ciotti were both available, that they failed the second prong. He did not find that with regard to Janice Dawson. He, excuse me just a second. I made a chart. He found with regard to the second prong, Ciotti, James, and Wells also all failed that second prong. The only one he didn't find was with Dawson and Berrien. Why Dawson did not fail that second prong, I don't know, because she hardly should have. She was with him in 1985. James was murdered prior to the filing of this 1989, the first 3850. Anybody that knew Vernon James, Sandra James, would have been able to find Janice Dawson. They didn't find that. With regard to John Berrien, that may be the only one that they can contend they couldn't have found in the second one, because they put on witnesses who said that we hunted for him, we went to family members, we couldn't find him, he was in prison. But the problem with that is John Berrien was available at the time of trial. And the information that John Berrien testified to here that he confirmed was also available at the time of trial. He gave a deposition prior to trial saying that he had made up this information. When he gets to this evidentiary hearing, although he initially alleges coercion, the final sentence that he says to their lawyer on redirect examination is, well, they didn't really do that. I was just saying things that I thought they wanted to hear. But nevertheless, he's saying things that inculpate himself. So John Berrien's testimony in this evidentiary hearing goes back and forth depending upon who's examining him. He confirms, denies, reconfirms, denies, back and forth. It was very fluid. He specifically alleged in his affidavit and initially on direct examination that the interview where he was coerced, that immediately thereafter he was arrested. That interview was his second interview. It was not the first interview. The trial court heard the tapes of his confessions. He heard the police officers who interrogated him, and he heard Berrien's testimony, and he specifically found that Berrien's testimony was not credible. Therefore, it fails the third prong. But let's go back to Dawson and James, and specifically Wells. Wells is the only person who testified at this evidentiary hearing that Vernon James had said he'd done this. But what Wells testified to, and to put this in the best spin possible for Mr. Wells, because it is disturbing that a lawyer would stand by, have this type of information, and not do anything with it. But Mr. Wells testified at the evidentiary hearing that it was his impression that it was a homosexual dispute, that it was an advance that had gone wrong. But he repeatedly said, I don't know if I'm testifying to this because he said that or if I got this through discovery materials. But it was my impression that it went this way, and I think he was alone. I mean, there was not a definite statement that he said, I specifically remember Vernon James telling me he did this by himself and that he committed this murder. It is inconceivable to me, inconceivable to the trial court, that he otherwise would have let his own client plead guilty to this crime when he is now saying that he has a witness who says, I committed this murder alone. The only thing that I can suggest is that possibly, as he stated at the evidentiary hearing, he was confusing the discovery materials with what was actually said to him. Nevertheless, the trial court, although counsel states that Dwight Wells was found to be credible, it is obvious that the trial court struggled with his testimony and ultimately chose not to believe him because he said his testimony was sketchy, that it was inconsistent with the facts, and he did not afford relief on it. So obviously he did not believe that Dwight Wells had this statement and kept it to himself. All of the other witnesses simply testified that Vernon James said he was involved, that he had set up the murder, the robbery murder. The state's theory at trial all along was that there was a black male that had a homosexual connection to the beauty shop that had set up this robbery. The state had originally contended that this was Franklin Brown, although they made it clear to the jury that they were not sure who this person was. The testimony that they've now presented, which they could have clearly found before and is therefore barred, nevertheless does not exculpate the defendant in any way. As for their Brady and ineffective assistance of counsel claims, again, it's the state's position that these claims were barred. They state in their reply brief that the state did not argue this below. The state certainly did argue this in an initial response to their 3850. The state clearly maintained that these claims were barred. And specifically with regard to the Brady claim, I'd like to point out that the Brady claim is based upon the assumption that Berrien's testimony was coerced. Berrien himself backed off of that in his testimony at the evidentiary hearing. Nevertheless, the trial court specifically found that this man was not a credible witness and that he was not to be believed. Given all that, he still confirmed that he drove them to the beauty shop, that he waited 2 hours, picked them up afterwards, and that the next day he drove them to the train station. This was also confirmed by physical evidence at the trial showing the ticket that George Berrien used to take this train the day after the murder. The state has no further. Thank you.
All right, thank you very much. Ms. Anderson?
Thank you, Your Honor. Regarding the state's argument that since this is a second 3.850 motion, Mr. Melendez has to show the witnesses couldn't have been found for the first 3.850 motion. In the lower court, Mr. Melendez presented evidence from prior investigators and attorneys on Mr. Melendez's case, prior post-conviction investigators and attorneys, that the evidence regarding the Mr. James' inculpatory statements and John Berrien could not have been located for the first 3.850 motion. The state didn't contest any of this evidence. In its post-hearing memorandum, the state didn't argue that this evidence could have been found by post-conviction counsel. What the state did argue is that the evidence could have been discovered by trial counsel. If that's the case, if it's not newly discovered because trial counsel could have found it, then trial counsel was ineffective. Trial counsel testified that this kind of evidence was entirely consistent with his theory of defense at trial, and that he would have presented it had he known about it. The state, Mr. Melendez maintains his position that the state has waived any argument that this evidence could have been discovered for the first 3.850 motion because the state didn't contest that at the evidentiary hearing and the state didn't contest it in its post-hearing memorandum. Regarding Mr. Wells' testimony, the state argues here that Mr. Wells said he wasn't sure whether he was remembering what Mr. James said or whether he was remembering what he found out from discovery. Well, there wasn't anything in discovery about Mr. James making statements. And when Mr. Wells made the comment about discovery, he was talking about another subject entirely. What he said about what Mr. James said is, he told me that he was involved in the murder of Mr. Dell. He described to me in some detail what had gone on, that Mr. Dell had come on to him in an overly aggressive way, and that's what led to the homicide. Mr. Wells was very clear that Mr. James had made this statement to him. Thank you very much.
Thank you very much, counsel.